I'm Karen Lovitch, and I'm chair of the health law practice at Mintz, and I'm joined here today by my colleague, Theresa Carnegie. We'd like to talk a little bit about the proposed changes to the Stark Law and Anti-Kickback Statute regulations that were issued by HHS back in October. And so, Theresa, I know you know quite a bit about those safe harbors and exceptions, so it'd be great if you could tell us a little bit about them.
Yeah, so I think the value-based safe harbors are one of the biggest headlines of these new rules. And these safe harbors are really intended to increase the adoption of innovative payment methodologies and to increase care coordination with respect to patient care. For a long time, the federal anti-kickback statute and the federal Stark Law have been seen as an impediment to the adoption of innovative value-based and outcome-based payment arrangements. Those laws were enacted in a time when the predominant payment methodology was fee-for-service. And so the intent of those laws was to prevent overutilization of services reimbursed by federal healthcare programs in a fee-for-service world. Since enactment of the Affordable Care Act, the healthcare system and government agencies have been trying to move healthcare reimbursement methodologies to focus more on value-based care, focusing on the outcomes of patients and focusing on coordinating care and taking care of the entire patient across their entire health journey.
So are there limits on who the parties to these arrangements can be under the exceptions and safe
There
harbors?
are limits primarily focused on arrangements between health plans, hospitals, and physicians.
So I know that pharmaceutical companies as well as medical device manufacturers are, very interested in value-based care arrangements. So is there going to be, some sort of safe harbor, for them?
Yes. HHS Secretary Azar at a briefing and press conference indicated that HHS is in the process of separate rulemaking specific to the purchase of pharmaceuticals and arrangements between plans and manufacturers. And we're hopeful that those would come out as well because there are some different considerations and they are very much needed in the context of those of rebate arrangements and drug purchase arrangements. So, obviously the value-based safe harbors are one of the biggest headlines of this new rules, but there's a ton of other exceptions and safe harbors in those rules, and there's a lot to unpack. So maybe, Karen, you can talk about a couple of those other areas.
So in particular, there are a number of terms that are used throughout the Stark Law proposed rule, which I'm sure you know, that are either ill-defined or have never been defined at all.
And have frustrated stakeholders for many years.
And it's particularly important because the Stark Law is a strict liability statute. And so it's very difficult for stakeholders when terms are not defined because, there's a lot at stake there.
There's no leeway.
No, none.
In certain areas, there is welcome clarity on some terms that have historically not been defined.
I think CMS really is open to receiving comments and hearing from the healthcare industry on the pros and cons of the proposals.
Right.
I wanted to highlight one proposed change to the kickback safe harbors that I think is really welcome by the healthcare industry. The safe harbor requires that your compensation be under the arrangement be set in advance.
That the aggregate compensation
across
the term of the arrangement be set in advance.
And so an example would be a hospital entering into an agreement with a physician to provide medical director services. Right. And you can't comply with the requirement if you, for example, set an hourly rate, which often is the most accurate way to ensure that compensation is fair market value.
Because one of the other elements of that safe harbor is fair market value. Right. And many instances where you can argue, and it is in fact true, that if you set an hourly rate or you set a per unit of compensation structure, that will more closely approximate fair market value because you will only be paying for the services you're receiving as opposed to having to estimate at the beginning of an arrangement how much services you will be receiving.
So under the proposed rule, as long as you set your methodology for the compensation in advance, then you've complied with the safe harbor.
I think one caveat to that you and I were discussing is another element of the personal services safe harbor is it requires that the compensation doesn't take into account the volume or value of business between the parties. So it's important to still consider that element of the safe harbor in determining the compensation, because even if you set the methodology in advance, if you don't meet that element of not having the compensation take into account the volume or value of referrals, you may still have a challenge in complying with the safe harbor. Karen and I have really just scratched the surface of what there is in these proposed rules, because remember, it's both this kickback statute and the Stark Law. There's a lot of other areas to cover and unpack there. We have a blog series that covers various aspects of the proposed rule under both Stark and the Anti-Kickback Statute. And go into detail there. So we would definitely recommend that you go and look at those if you have additional questions or would like to understand some of the areas that we haven't covered today.